3, 2, 1, start. The petitioner has invoked the writ jurisdiction of this court seeking quashing of the order whereby its technical bid was rejected by the respondent authority in an e-tender process. A further direction has been sought to permit the petitioner to participate in the financial bid and to consider its offer in accordance with the terms and conditions of the tender notice. The respondent department issued a notice inviting tenders for maintenance and operation of certain public facilities for a period of 2 years. The petitioner, being engaged in the relevant business, submitted its bid through the online portal within the prescribed period. Along with the bid, the petitioner uploaded the required documents including registration certificates, details of previous experience, financial statements, and proof of deposit of earnest money. After scrutiny of the technical bids, the petitioner was informed through the online portal that its bid had been declared non-responsive on the ground that one of the experience certificates did not contain the complete particulars required under the tender conditions. According to the petitioner, no opportunity was granted to explain the alleged deficiency and the bid was rejected without assigning detailed reasons. Learned counsel for the petitioner submits that the alleged defect was neither substantial nor incapable of clarification. It is argued that the certificate in question clearly established the requisite experience and all material particulars were available from the supporting documents already uploaded with the bid. The authority could have sought clarification instead of excluding the petitioner from the tender process. It is further contended that rejection of the bid for a minor technical defect is arbitrary and contrary to the principles of fairness and equal treatment. Per contra, learned counsel appearing for the respondents submits that every bidder was required to comply strictly with the conditions contained in the tender document. The petitioner failed to furnish the experience certificate in the prescribed manner and cannot claim any right to cure the deficiency after expiry of the last date for submission of bids. It is further submitted that interference by the court in contractual matters is limited and the decision of the tendering authority should not be substituted merely because another view is possible. Having heard learned counsel for the parties and perused the record, this court is conscious of the settled principle that the author of the tender document is ordinarily the best person to understand and interpret its requirements. Judicial review in such matters is concerned primarily with the decision-making process and not with the commercial merits of the decision. However, the action of a public authority must remain fair, transparent, and free from arbitrariness. In the present case, the rejection communicated to the petitioner merely refers to incomplete particulars in the experience certificate without identifying the precise requirements which was allegedly not satisfied. The record further indicates that the petitioner had uploaded additional documents containing information relevant to its previous work. Whether those documents were sufficient to meet the tender requirement was a matter of consideration by the competent authority. The court does not consider it appropriate to declare the petitioner technically qualified or to direct opening of its financial bid at this stage. Such determination falls within the domain of the Tender Evaluation Committee. Nevertheless, where rejection has serious civil and commercial consequences, the authority is expected to record reasons sufficient to demonstrate that the relevant material has been considered. Accordingly, the impugned decision rejecting the technical bid of the petitioner is set aside. The competent authority is directed to reconsider the technical bid along with the document submitted within the stipulated period and pass a reasoned order in accordance with the tender conditions. The exercise shall be completed expeditiously, preferably within 7 days from the receipt of a certified copy of this order. It is clarified that this court has expressed no opinion on the merits of the petitioner's eligibility. The writ petition stands disposed of in the aforesaid terms. All pending applications, if any, shall also stand disposed of. Stop.